We're talking all about today, what landlords should do in the event of early termination. Early termination happens, and it happens not because anybody has necessarily done anything wrong. Sometimes stuff just pops up and it's advantageous for the landlord to terminate early or for the tenant to terminate early. And so what are the best reasons to do it? What are the best mechanisms for doing this? And what can you do, knowing what you're going to find out today, to position yourself in the best possible way whenever you want to terminate early or whether the tenant wants to terminate early? There are some times when there are things that just come up. One big thing came up recently. How many of you were around in the month of July? Anybody remember Hurricane Beryl? Right. Hurricane Beryl came through and changed a lot of rental property. Hurricane Beryl came and said, I don't care what your lease says, I'm gonna... And it created problems, not just for tenants, it created problems for landlords. And one of the common problems was, my home caused damage to my tenant's stuff. Am I responsible for that? And many of you didn't know. Many of you thought, just like your tenant told you, well, you have to pay to put them in an Airbnb, or you have to pay for their hotel, or you have to pay to replace all of the stuff they lost because your house was damaged through a storm. But the truth is, none of that's true. I'm going to get to a portion that many of you already have in your leases, but maybe you just don't know are there. And because of these protections, we sometimes end up spending large amounts of money that you were never ever required to spend. Instead, you may have wanted to elect the option to terminate your lease early. Well, how could you possibly do that? How is it fair that the tenant who signed a lease, with whom you signed the lease, and agreed to supply a residential unit to, all of a sudden doesn't have a residential unit because a hurricane or a tornado or a flood or a fire rendered that unit 100% or virtually 100% uninhabitable? What do? They're going to yell and scream and say, I paid rent for this month. I deserve a property. Well, what does the code say? Well, the Texas Property Code has a section specifically for this issue. The Texas Property Code already thought about this because guess what? This has happened for a gajillion years. This is not a new problem. And so what the code says is, stuff's gonna happen, and it refers to them as casualty losses. These are events that come through no fault of either side. Hurricane Beryl was not the landlord's fault. Hurricane Beryl was not the tenant's fault. But Hurricane Beryl came through and it changed things. And so the first part of this says, if a condition results from this, and there's a loss, and there are specific sites, but this is not an exclusive list, the period for repair does not begin until the landlord receives insurance proceeds. Probably didn't know that. They're yelling and screaming, you got to do this right now. And while it's true that you should act with diligence, it is not true that you need to get started 2 hours after the hurricane passes through. That's just not true. You have a reasonable opportunity to call your insurance company, to get an insurance adjuster out there, to get estimates, to buy supplies, and then begin the process. But until you receive insurance proceeds, you're really not on the hook to do anything. You are required to act with diligence. It doesn't mean you can sit on your hands and just wait until you're ready. You got to start making phone calls and getting things ready. But the truth is, you don't have to jump just because your tenant says jump. Whether that's a 100% loss or a 10% loss is not what matters. If there's a casualty loss of any amount, you don't have to do anything until you've had your insurance take a look at it. Mostly what I want to talk about is what you can do if the place is either a total loss or a partial loss in this, and why it makes sense for you to terminate, but why the tenant has the exact same right. So let's take a look at the first scenario. If after a casualty loss, as a practical matter, the whole thing is unusable. the whole thing. And it goes on to explain that, you know, it can't be caused by the tenant. And I'm like, well, there was a fire. I set the fire, and I'm sorry. If it was caused by their negligence or their willful intent, the rules are a little different. You can just get rid of them. But here, let's assume that it's a casualty loss caused through no fault of either the tenant or the landlord. What do you do? So imagine you're in the middle of the month of July, and a hurricane, whoop, takes the roof right off the house. If a house doesn't have a roof, it is 100% uninhabitable. I had a client who called and said, not only did my roof come off the house, it came off the house and crushed my tenant's car. And so now my tenant's screaming about a place to live and a car to drive around it. Do I owe him a car? The short answer is no. And we're gonna get to that provision of your lease. And if you got a good lease, you've got it. If you don't have a good lease, then you're gonna have to resort to what the code says. But the short answer is no. So what do you do about the house when it's 100% uninhabitable? Well, they could wait. They could wait and just say, you know what, we'll just wait until the house is habitable. I'm gonna go live with my mom in the meantime, but I really, really like the location, or I really, really like the house. Do they have to pay rent? That's debatable, and we're gonna talk about that in the next segment. But the other question is, do you have to wait? Because it might be very difficult for you to complete repairs when all of their stuff is there, right? So it might be convenient for you to exercise what this provision of the code says, is that either they or you with a written notice can say, done. Sorry, 100% loss, you can't stay here anymore, you now have to go. For the tenant side, they may do that first. They may say, hey, I gotta go, I need a place to live. I don't have mom's house where I can move to, I need to go somewhere right now. And they terminate perfectly within the law. And what the law says is that for the rest of that month, once they've moved 100% of their stuff out, they're entitled to a refund of the rent balance, not from the date of loss, from the date they get all their stuff out. So if that's 1 day or 10 days, that matters. And then 100% of their security deposit. In that event, they have the right to exercise that. Now, sometimes they're, again, demanding hotel costs, demanding costs for losses of personal property, demanding for this and that and this and that and this. None of that's on the table. If you read the provision, it only entitles them to a refund of prepaid rent after they leave and the security deposit. That's it. We're gonna get to the other losses in a second. But for now, you can terminate and say you have to leave, because the most effective way for me to 100% rehabilitate my 100% loss is for you not to be 100% in the way. It might be convenient for you, and usually is, number one, to shut down all of these claims. I'm gonna give you some more firepower on those claims in just a second, but in terms of the tenancy, you're not on the hook to wait for them to make the decision. You can preempt the decision, and I recommend that you do in the event of a casualty loss. Subsection C talks about a partial loss. So in this case, let's say the only thing that was lost was one room. Maybe it was a bathroom, maybe it was one of the bedrooms, but that the family can still live on the property otherwise. You wall off that area while the repairs are being done. They cannot use it. So that portion, let's say it represents 10% of the rental unit, that portion of the rental unit is uninhabitable. But 90% of the unit is perfectly habitable. Guess what? You can still charge 90% of the rent, no problem. They can continue to live there, but what the code says is you and they can work out what it means in terms of reduced or diminished value. And so I encourage you strongly to get ahead of it and say, look, I'm on it, my insurance is gonna come, my adjuster is gonna come, and any time that you are without actual use of whatever this portion represents, whatever square footage is there, I'm gonna deduct that. Now they may say, I can no longer live here. The only way they can do that is if they can prove what section B said before. 100% or virtually 100% of the home is uninhabitable. The fact that only 10% is uninhabitable does not let them off the hook. If they want to early terminate because 10% of the unit is unusable, that's not what the law allows. So you can kindly say, no, you don't have to accept that no matter how high they jump or how loud they scream, you can say no. And that's perfectly okay. As long as as a practical matter, there is still a majority of the house left. Once you start getting to the 75, 80%, then it becomes arguable that it is virtually completely uninhabitable. But when it's less than half, and really the house is still usable, you can keep them in place. Now, can you bargain with them? Can you negotiate a termination? That can always happen. Whether it's sunshiny or on fire, you can always renegotiate terms. But we're talking about when one side insists. The question is, are you required to do it? And in this case, unless it's a significant amount that could, again, arguably be 100%, the answer is no, you're not required to do it. 10, 15%, you reduce the rent for the number of days that the unit is uninhabitable to that portion, and that's it, they get a discount. They don't get an automatic out. Sometimes you're gonna have a situation where a husband and wife no longer like each other. This happens a lot. Husband and wife sign the lease, but in the middle of the lease, one of them says, sayonara, I'm out, I don't wanna live with you anymore. And they leave. And that person tends to be the one who insists, take me off this lease. Can you say no? Absolutely you can. They don't deserve an out. There's no legal mechanism for it, short of some court order. And those are very rare. But short of a court order saying, you must release them from this lease, they don't get an out just because they are splitting up. In the event that either a set of partners or a married couple who both signed the lease, or two roommates, they don't even have to be in a romantic relationship. Sometimes you have college kids who are splitting a unit and two of them want to go and two of them want to stay. You are not required to release the other two just because they're graduating. That's not a clause in your lease, probably. So no, you're not obligated in that respect. You're also not obligated to accept whoever they find to replace them, especially if they don't meet your standards for your normal application process. So remember, they are locked in and you are allowed to keep them in place for as long as they are there. So you're gonna get requests from your tenants from time to time, I want out. And again, unless there's a legal mechanism for it, like 92.054 that I showed you before, where there's been a casualty loss, you're not required to do it, you don't have to do it. And I don't encourage you to do it because you become less secure the fewer people that are on the hook. If they want to split up, there are consequences to that, sometimes economic and financial. And they may tell you, look, I'm trying to get a place somewhere else that I can't because I'm still obligated here. I mean, I'm sorry, it's complicated, it's rough, but I didn't cause that complication. I was never in love with you to begin with. So I don't know why I have to in any way assist you. Now, just like in any situation, can they buy themselves out of your contract and modify it? But there's another party involved in that lease modification. Who needs to participate in a lease termination for it to be valid? Everybody. Everybody's got to be on board with that lease termination or it doesn't happen. In this scenario where we have one person who wants out, we might have another person who says, you're not going anywhere. And they don't have to agree to it. Even if the other person offers you a ton of money, because you and that one party are in agreement, but you and the other party are not, that lease does not get modified. And so it's important for you to know, you cannot deal exclusively with one party when two parties are involved in the deal. So this is another thing that happens from time to time where one person, particularly with the security, it's always with the security deposit. They want out and they want their half of the security deposit on their way out. That's not a good idea. And it's typically not something that the other tenant is going to accept. But if it is something that you accept and they accept, I'm still telling you, it's not a good idea. Number one, unless somebody's gonna refill that, and it could be the remaining tenant, now you're less secure. Problem. Number two, unless that remaining tenant by themselves can afford the unit and would have passed your application test, it's not a good idea to have them as the only remaining person on the hook. And then number three, as always, The more people you have who are culpable for all of the requirements in the lease, the likelier it is that all of the requirements of the lease will be met, particularly those that have to do with payment. And so the fewer pockets you can pull money out of, the less secure you are. So when it comes to a split, and when it comes to modification of that new contract with the remaining party, make sure you've considered all of these things: the security deposit, the creditworthiness and the earning capacity of the remaining tenant, and the fact that everybody has to be on board with this modification. You sometimes need to be able to make it very clear to your tenant that you have the right to terminate early. This is probably one of the strongest provisions in your lease when you experience a casualty event. And what it says is all the things that are in 92.054 in the code, and it further goes on to say, any proceeds, payments, damages, settlements, awards, or other sums paid because of the casualty loss to the property will be whose? The landlord's sole property. For the purpose of this lease, any condemnation of part of the property is casualty loss. Listen, it's important for your tenant to know just how far your insurance stretches. It covers you. It does not cover them. Now, some of your leases suggest that the tenant purchase insurance. My lease has the option to require it, because in these events, your tenant is going to be convinced they can sue you. And even if you have a provision like this, that doesn't stop them from trying to sue you. But if your lease explicitly says you are required to have insurance, and you're not having insurance as a default that I can use against you, then guess what? At lease signing, you can see proof of insurance. And the fact that they don't have it is a reason for you to deny them the keys. It's a reason for you to deny them the tenancy. It's a reason for you to preempt any claims in the future from future loss. Remember, their insurance protects them and their stuff. And the better insurance they have, the higher protection. They might have insurance that covers their loss of personal property. They might have insurance that covers their lost use of the tenancy. It might put them up in an Airbnb or a reasonable hotel and cover other kinds of losses that they're gonna blame you for, but that this section of your lease should protect you from. I have a very similar clause in my lease. Understand that these provisions are there to protect you when somebody cries foul. You have no liability for the things they lost. You sometimes need firepower. But you also sometimes need to know when it makes sense to let a tenant go. There are certain situations where it makes 100% sense for you, once the tenant says, I'm thinking of leaving, to say, let's make that happen. Right? And you're gonna be the best judge of that when it makes sense for you to say goodbye to a bad tenant. Because if you're already thinking, I'm probably just going to evict you anyway, let's just get ahead of this and terminate. So you need firepower when they're belligerent about it, but you also need a little bit of wisdom when it makes sense to let a bad one get away. I don't know how many times I review leases that look exactly like this. This is the section of the lease where notice is supposed to be posted, and many times it is blank. That means the only way you can notify your tenant is by either putting it in their hand, mailing it to them, or affixing it to the inside of the main entry door, which is cumbersome and difficult to prove. And what if they're not even living in the house because there's been a casualty loss? How do you get notice to them? If you mail it to them, it's going to go to the house. They're not living there right now. How can you send them notice of termination? And so it's important, number one, to be ready to send all kinds of notices, but in particular the notice of termination, and to be able to prove to a court that you did it. And so if you look at all the empty retail space here, you want to give a good way for them to contact you. You don't have to give your personal address, but I do suggest that you get a P.O. box or one of those mailbox addresses where if they're going to send you a letter, they can send you a letter. The property code requires that the owners of property, within 7 days of a written request by a tenant, within 7 days, disclose the name of the owner of the rental property and a mailing address. And if you don't do that, guess what? Your tenant can unilaterally terminate the lease for free if you don't supply the name of the owner and a mailing address. And if you are the owner and your only mailing address is your personal residence and you don't want to share that, make provisions for this part of the law. Get yourself a P.O. box, because you're going to have to disclose these things. Now, if the owner is your LLC, even better, even more anonymity, but get your LLC a business mailing address where that LLC can be contacted. We know that the LLC has to have a registered agent, and the registered agent can't be a P.O. box, but they can use a business address for contact purposes. Does anybody still use a fax? I'm required to. I get about one fax every 2 months, but I just always wondered about that. What this should be replaced with is text. Now, between me and you, I don't like texts, because texts tend to be informal. Like, I don't want to have to prove up emojis to a court. Your Honor, this is 2 sad faces, and I don't need that. I would prefer that there be language that is clear, and when it's coming from you, it should always be on a professional level. And so what do you put on this side? Well, you don't need the mailing address, but you could put the mailing address for sure. What you do need are multiple email addresses. Most people have at least 2. Most people have a business address and a personal email. And when there's 2 tenants, guess what? That's 4. And if they're not here, you're missing out on opportunities to prove that you validly delivered notice. Because guess what? A notice of termination, a notice of non-renewal, a notice of default, all of those can be delivered by email. Your notice to vacate is the only one that can't. That one's controlled by a different by different portion of the law, but all other notices you can deliver by email. You might have a tenant portal, right? So you may use tenant management software. That's extremely helpful. Mention that here. For purposes of notices, you can deliver notice through your tenant portal. So these are all helpful things that make it very easy for you to navigate through the law. When you have to give a good notice, you want to be able to prove that you already agreed that they can get notice through email. Now, we always like the backup of regular and certified mail. That's helpful, but we tend to argue there's no such thing as too much notice. That doesn't exist. But insufficient or inadequate notice is rampant in landlord-tenant law, and it destroys cases. It costs money. So just get ahead of it and fill in. How do I send a notice? Make sure you're given the opportunity to send it through alternative means. And then who should get notice? Everybody. All the listed tenants. List them all, notify them all. Don't leave anybody out. Make sure that they're all on notice that the lease will be terminated. What you don't want is an argument that, well, you only terminated one of us, not both of us, so I get to stay. Again, get ahead of that, notify everybody, make sure that your notices are clear and that they clearly go out to all of the necessary parties. Now, for those of you who are just starting out or maybe just don't have a whole lot of experience with the eviction process, I have an offer for you that we are making available to all of our clients, particularly for those in Texas. If you have rental property in the state of Texas and are issuing notices or would like to learn a better way to issue notices and file evictions and even handle eviction appeals in the state of Texas, then you may want to check out our eviction course. There's a link in the description below, but you can also check out attorneyeg.com/EV for more information on that eviction course. We walk you through the process of your notices, of filing, and even the kinds of things that you can expect at trial and on appeal. If you would like a course where we go step by step from notice to judgment to help you recover your property faster, I strongly encourage you to check out attorneyeg.com/EV, our Texas eviction course from start to finish. Again, I'm going to walk you through multiple modules. I give you samples of your notices, samples of an eviction petition, and plenty of resources along with my step-by-step training to help you file your own eviction with success. If you need more information, feel free to send us an email at info@attorneyeg.com and check us out at attorneyeg.com/EV for information on our Texas eviction course.